Under the Employment Rights Act 2025, huge changes are being made to trade unions, both in relation to how they're recognised, what they can do in terms of industrial action, and finally what happens about their regulatory oversight by the certification officer. One of the most significant parts of the Employment Rights Act 2025 is its effect on trade unions and industrial action. It introduces substantial reforms to strengthen workers' collective rights while removing restrictions imposed by previous legislation. Employers must give workers a written statement confirming their right to join a trade union. This statement must be provided at the start of the relationship, but also is likely to need to be repeated during the course of the individual's employment at times to be confirmed. How the information should be provided and the exact content of the notice is yet to be determined. Unions will have the right to attend the premises of an employer for the purposes of meeting, supporting, representing, recruiting or organising workers, even before they're recognised by that employer. Now, the right applies to physical access, as well as virtual access, such as via an intranet or email communications. And if an employer refuses access, the union will be entitled to apply to the Central Arbitration Committee for an order setting out the terms on which access must be provided. In addition to these provisions that essentially bolster the marketing efforts of unions, the Act also makes extensive amendments to the trade union recognition procedures. Currently, the rules for statutory recognition require at least 10% of the proposed bargaining unit to be union members, and at least 80% of employees in the affected area of the business needs to vote. Now, the Act allows the government to reduce the threshold number of union members to as low as 2% and removes entirely the turnout threshold. In addition, recognition agreements entered into by non-independent unions during a restricted period must be ignored when assessing admissibility. In other words, employers are prevented from making sweetheart deals with unions that they've helped set up, specifically to frustrate the recognition process. Union members are now contributors to the political fund by default, unless they give an opt-out notice to the union. That reverses the previous opt-in requirement. And trade unions must give opt-out information notices to members within 8 weeks of passing a political resolution and at 10-year intervals thereafter. And the restriction on deduction of union subscriptions from wages in the public sector has been removed entirely. In addition to the changes made to union recognition, a number of changes have been made to the requirements relating to industrial action. First, the turnout threshold, which currently requires that at least 50% of those entitled to vote must do so, will be removed. Notices to employers about industrial action ballots are simplified. The period for which an industrial action ballot remains effective is extended from 6 months to 12 months. And the notice period that unions must give employers before industrial action is reduced from 14 days to 10 days. And the detailed rules relating to picketing have been removed, and the protections for those taking industrial action have been strengthened. Finally, the oversight powers previously conferred on the certification officer have been drastically curtailed, meaning that unions will be subject to considerably less regulatory scrutiny than before. For more details, please head to our website mishcon.com and look for the Employment Rights Act Hub. There you'll see more information regarding the content of the Act, when different parts of the Act are coming into force, and what still needs to be decided. You'll also be able to download guides as to what employers should be doing to prepare for the changes and what training we have available for your managers and HR teams.